welcome to The Verdict Is In podcast. Today, I have Graham Ferris as my first guest, and I'm very excited to get into one of his journal articles. To act is to be committed, and to be committed is to be in danger. The vulnerability of the young lawyer in ethical crisis. Graham, would you like to introduce yourself?
Hello, I'm Graham Ferris. I've actually retired, but I still teach part-time. But I worked at Nottingham Trent University at the time that I was composing that article, together with two colleagues, Jane Ching and Jane Jarman. And it was one of a series of articles I did using vulnerability theory and looking at aspects of basically aspects of legal education and socialisation of lawyers in the UK.
So what is vulnerability theory?
Well, vulnerability theory has been developed by a woman called Professor Martha Feynman, and she works in Atlanta in Georgia in America, and she was looking at the way in which our assumptions tend to dominate the way in which we think about how people are, the way the state should act, maybe welfare benefits, maybe subsidies for businesses, maybe the way in which our roles are defined within society, whether it be in professional roles or private roles, such as within the context of the family. So she was looking at the way which we start, and she was saying, well, the starting point tends to be this idea of this autonomous adult individual who's able to make decisions and is able to use information to their own best advantage, and who usually acts in a self-interested way in which to maximise their advantage. And she said, well, that's all well and good if we were dealing with a fantasy, but in the real world, that's not how we are. In the real world, we're actually vulnerable. And all of us are vulnerable. It's a universal state of being. There's none of us that can step in front of a bus and come up smiling. It's just not something that happens. All of us at some point were children. And when we were children and infants, we weren't just growing into this kind of autonomous individual, which is different from all other individuals and unique, although no doubt we are all unique, etc. But we were actually being shaped by the things that were going on around us, by how we were parented, by the relationships of our parents, whether or not we had enough to eat. In fact, if you go back far enough, whether or not your mother had enough to eat when you were inside her womb will determine major life chances for you. Your health will be affected for the rest of your life according to that. So this idea that we're autonomous, like we're little kind of dots, is absurd, because what we actually are is we're vulnerable and we're constantly being affected by our environment. And that's the fundamental basis of vulnerability theory. It says, let's not assume these creatures who kind of don't have any links or aren't formed by life. Let's assume people as they are and see what difference that makes to our views of such questions as what is the right thing to do, what is the just thing to do, and what does a good life entail? What should you hope for from a good life? So those big philosophical questions, those jurisprudential questions, they shift. They do a kind of state shift, like when water goes to ice. If you shift the assumptions about the people you're talking about and what people are like, it shifts quite a lot of the resulting thought over what's the nature of justice and what's the nature of the good life.
Yeah, thank you very much, because that was a beautiful summary, and I guess you've had enough practice from teaching it on the critical legal thinking module. Well, let's get into the actual journal article.
Yeah.
So recently I spoke to a lawyer back home, and he describes the regulatory situation as being the SRA, the Law Society, and the legal ombudsman as all being against the solicitor in a situation where anything goes wrong. Do you agree, or do you think they're just being a little bit melodramatic?
Well, you can be melodramatic and true at the same time. That is possible. But I think what the solicitor is probably feeling, and I think a lot of people feel this outside of the legal field as well, is that regulatory bodies have kind of lost interest in whether or not you're trying hard and doing your best, and they've kind of shifted to a kind of a policing of your notes. So they're looking to see whether or not you've ticked boxes in the process, and if there's a single box unticked, although it was totally irrelevant to anything that went wrong, it's that box that was unticked will become the focus of investigation, and that makes people feel itchy, because if you're doing the job really well, the job of a solicitor, it's difficult in various ways. If you're doing it really well, you don't really have time to split your focus to think about, am I ticking boxes? And so it's almost as if, in order to do your job as well as you can, you're placed in a position where you have to take risks, because actually this client interview, if you stop to tick those boxes, you've lost that moment, and that moment will never come again. And so you're kind of to do your best, you have to be taking these risks, and it feels therefore that they're not looking to see whether you're doing your job well, because you're trying to do your job well. Almost all of us try and do our jobs well, but they're looking to see whether they can catch you out. And I think that's part of what your friend was talking about. The other thing is this fragmentation of regulation. Which has happened to the legal profession, where you've got the Law Society does relatively little now, but you have the Solicitors Disciplinary Tribunal, you have the Solicitors Regulation Authority, which is constantly, it seems, trying to increase its punitive powers. Thanks for that. And you've got the Legal Ombudsman. It's taking a kind of consumer complaint attitude to things. And part of the problem is, if they ask for slightly different things, that problem of someone's trying to catch me out becomes worse, because you're not only ticking one set of boxes, you're ticking three sets of boxes, and that just starts to be a cognitive overload. And it's not even useful, because all their slightly different boxes, in as much as they do have a good purpose, the good purpose is to try and ensure that you're dedicating yourself to the client and the job. And they change rules too often as well. So rules change often enough that you're never quite sure you're up to date, and you end up, nowadays, most solicited firms have an expert, the COPE officer, who is the person you go to if you have a regulatory concern, and they're probably the only one in the firm that's up to date on exactly what the regulations are demanding, and that again creates a problem. When I qualified, that was not the case. There was basically a single regulator, and the rules were well established. And yes, you needed to be aware of that. You have to comply with the regulations, but I don't think that sense of being kind of under attack was there. So I think that's what your friend was picking up on, and I don't think it's true. I don't think anyone is after your friend or solicitors in general, but I do understand why they feel like that. You get the similar thing in the medical field. You get a similar thing. Actually, you get a similar thing in academia, but far less intense.
Thank you. That was a very, very comprehensive answer, and I'm actually kind of interested to hear more about, why do you think they moved away from one single legal institution to multiple?
Okay. Now that's actually a really complicated answer, so I'm going to simplify a little bit, just because elsewise I will exhaust any patience that any watcher has. One problem was that solicitors under the original regulatory scheme, which was run by the Law Society, the problem with that, and it was a problem, was that there was a tendency for that particular regulator, being based within the profession and of professionals, to not be assiduous enough in pursuing complaints. So client complaints weren't always being handled well, because there was a kind of a tendency for solicitors looking at solicitors and being sometimes overly sympathetic to the difficulties of practice. And that was a genuine problem. So that was one thing. Something else that was happening was there was an attack upon the idea of professionalism. The professionalism was seen as something which was a bad thing. And this is associated with those changes which are associated with Margaret Thatcher and Ronald Reagan, and I would call them neoliberal. Sometimes people call them free market reforms. It doesn't really matter what we call them, but one aspect of that is the idea that the best way to regulate any economic activity, and in fact many public activities, is to use market forces. Yeah, and market forces don't like professionalism, because professionalism holds some monopoly practices to its profession. So, for example, rights of audience in the courts. And those monopoly preferences were seen as inherently bad, seen as an inherently bad thing. So that meant there was an attack upon professionalism as an idea. And that attack went on. It's not a party political thing. So in 2007, that was probably the single most damaging attack on professionalism, and that was under a Labour government. So it's not a party political thing, but it's about this idea that professionalism is suspect, professionalism is a bad thing, and therefore we need a different form of regulation. And that's basically what they started doing. They started producing new forms of regulation. The legal ombudsman, for example, is based upon an idea of protecting consumers. The Solicitors Regulation Authority, it's actually designed, it's based upon a model for financial services, the one that just preceded the global crash caused by financial services. They've actually copied the failed model for legal services. Oddly enough, it isn't working as well as one might have hoped. So there was a kind of a shift, a kind of ideological shift, as well as a genuine problem. And because, you see, the advantage of professional regulation of professionals, disadvantage is this conflict of interest. The advantage is that the professionals that are regulating know what good practice looks like. The people that regulate now tend not to know what good practice looks like, and that's why they go for these checklists, these audit trails, because that's what they're looking at. They're not actually looking at practice. They're looking at those signs which they've identified as indicative of good practice, and that's what generates this feeling that they're not looking at what you're doing, because they're not. Because the people with the knowledge and experience that would be able to judge whether you were doing a decent job, they're not the people now that are regulating.
Thank you very much. That was a very, very detailed summary, actually, but it's all very interesting stuff, and I think that it's something that hopeful legal professionals definitely should know before entering the industry, because this definitely seems like something that isn't just going to be left as it is. It definitely seems like an issue that needs some kind of development or regulation, and the only way to do that is if everyone is aware of what the problems are. So yeah. Thank you very much. Let's move on to the article. I'm going to read out a quote so that everyone listening can kind of understand why I'm going to ask the questions that I do. It's a fairly simple one first though. You state that as teachers ourselves, we have experienced the occasional panicked phone call from former students faced with ethical issues that they cannot resolve. This experience of being the last resort demonstrates the gaps that already exist in the educational continuum. How often do you get phone calls like this?
Me, never. This is my co-authors. So because my co-authors both taught on a professional programme, people that were going into practice would have been taught ethics for that practice by them. And so the truth be told, although it says we collectively, it was them. Basically what was happening was people they understood what they understood when they were doing the professional courses, which were well designed and well delivered. And so when they got into the practice situation and things weren't what they were expecting, they had a kind of reaction of, is it me? Because I thought that I'd been taught and that I understood that this would be an improper thing to do, and yet people who I have to trust, because this is the firm, this is the new professional life I'm trying to learn, they're doing it differently. And so they resorted back to my co-authors, and I think other people that teach on those professional courses, and they've said, have I got it right? Is it me? Or is this something which I'm going to have to think about challenging? Because it's really scary challenging people in a law firm. Basically, lawyers have a front. It's part of the job, and when you're challenging them, they turn their defensive front on, and it's very difficult to read them. It's very difficult to know what the consequences will be, and so having someone they could resort to that they trusted, that they knew were an expert, was really a really valuable thing for those young people.
If I'm ever in ethical crisis, can I rely on you for your ethical judgment?
Yes, but almost certainly I will be wrong. That's my speciality.
So do you think there should be some kind of lawyer in ethical crisis hotline, something maybe a bit more accessible and laid back where a lawyer can express their concerns, or do you think the field's just too regulated and too kind of important for something like that?
Well, at the moment, the Law Society provide a telephone line. You can phone. They have done for many years. When I was in practice, I phoned up about something which I think was not a problem, but I wasn't sure it wasn't a problem. Basically, they talked it through, and I decided it probably wasn't a problem. I'd raised it with the solicitor that was supervising me also. I talked it through with him. So that still exists, that hotline. Hotline makes it sound a bit more exciting than it is, but that still exists, and that's a useful thing to exist. The advantage you get from someone you know and trust is that you've already got a relationship, because when you phone up the Law Society, you're phoning up a stranger, and it's difficult to. As you build a relationship with people, you realise how they react and what a reaction means. Like, for some people, a raised eyebrow is a really big issue. For other people, a raised eyebrow just means they've got a twitch. And you don't really know until you know, and that comes from the relationship. So there is certainly there's an added value. Also, some of the advisors, I've known the advisors on the Law Society helpline, because they don't want to be wrong. They can be uncommittal in a way which isn't useful if you're trying to feel your way. When they talk things through with you, that's really useful. But sometimes I think you get a problem that because they don't want to be wrong and these things are complex, they're too uncommittal, and you're left a bit dangling. So I think it's a really good service. I think we're lucky to have it. It'd be terrible if we lost it, but it doesn't do all the things you'd want to do for somebody that's in that position.
Well, it's nice to know that it's there if I need it. Yep. But I will be coming to you first. Focusing on people who are interested in entering and engaging with the profession ethically. So this is another quote. The professional and regulatory structure within which they find themselves, that they being the junior lawyer, assumes that they are autonomous, unconflicted moral actors who are able to translate classroom coverage of professional ethics into action in the workplace, and who can be disciplined if they failed to do so, irrespective of any repercussions from their employers. Their ethical autonomy is assumed, a given, not something needing to be constructed or supported, as this is the necessary resilience as an internalized characteristic not needing external support to maintain this autonomy. If the individual falls short of this requirement, then she is, on this analysis, justly punished, for she has failed to exercise her autonomy ethically. They encourage you to give them information and then hang you out to dry. So this is what I mentioned before we started recording, but do you think that people who have just entered the legal profession, let's say just been admitted as a solicitor, should have a lower standard than legal professionals who are more senior? And obviously this is important to contextualize, because I don't mean should you let them get away with bloody murder. I'm asking, do you think that their newer status should be more contextualized than it is at the moment?
Okay. Now this is kind of a difficult one. In one way, the standard has to be the same, because we're looking at standards of professional conduct. And we're looking at, because solicitors have the ability to take advantage of clients because of their greater knowledge base, because of their experience, because of things like that. So we have to have a protective code of ethics if we're going to have a profession. We could go for a pure market situation, and I think that I would call that a danger, and I think there is a danger that is the direction of travel for the UK in particular, more so than the US. In this respect, the UK is more American than the Americans. So if we're not doing that, then we're going to have a standard of conduct. We're going to have to say people have to behave so well. That's one thing. That's about the standard. I guess the objective standard which applies for professional conduct. However, within that, one has to recognise that the situation in which you're acting means that the demand that you meet that standard is actually a very different demand for different people. If you are within a firm where there is a good workplace culture where the client is placed first, where the idea of side selling the client insurance, or the idea of kind of pushing the client towards a further stage in the litigation process, which is probably not going to be to their advantage but would pay well, any of the various quite terrible life-destroying things you can do to clients if you're manipulating them. If you've got a workplace which is doing that, saying no is a lot more difficult in the wicked workplace than it is in the good workplace. So although the standard is the same, what we demand of people before we decide that they're behaving in a way that's culpable, in a way that should be punished, I think that's different. I think that should be different. We should have a system of regulation that takes that into account. Elsewise, we're expecting the little German chap from an earlier conversation that's going along to his Hitler Youth to say, oh, actually, the Führer's wrong about the Jews, and I think we need to reassess our position on that. A, he's not going to do it because psychologically it's impossible, and B, he's going to get beaten up if he tries. It's foolishness to see people in different situations and demanding that they behave in the same way. It's a part of this autonomy thing. It's refusing to see that the assets which enable one person to act well aren't necessarily available for another person. Therefore, acting well for them is far more difficult. So I think that has to be built in to the process. Something else that really should be built in, and I think in some ways I'm more concerned with that, is we have to help people do these difficult things. It's hard when you have identified an ethical problem that other people around you have not identified you. They don't want to be called out. You'll make yourself unpopular. That's the best scenario. The world is not kind to whistleblowers. Few whistleblowers maintain the relationships they had before they blew the whistle. That is the reality of it. We're asking people to do something hard, and instead of seeing ways in which we can penalise them in order to encourage the others, to use an expression from history, in order to encourage the others, we punish you. Instead of kind of looking with that aspect, we should be looking, how can we build, how can we support, how can we help? What assets of resilience, what social, what existential, what institutional, what political, what legal tools can we give to people who will do the right thing given the support? Yeah, that's kind of where regulation should live. It shouldn't live in who's the easiest to punish. That's the worst scenario, where you're punishing the person that's doing well in a bad situation. But we should be looking, how do we support people who want to do the right thing, because it is hard to call the ethical tune out. It is hard when something is going wrong. You doubt yourself. You need support. You need people, to go back to the earlier point about the trusted other from education. You need kind of the code. You need the authority behind it. You need stuff like that because it is hard. Because I think it was Aristotle that said that no one should be expected to be of moral character until they're in their 30s, because it's a learning process and it's hard. It's not something that is automatic. And that's the problem with this autonomous individual. For them it is automatic because it's built into what we're assuming they're like. And people aren't like that. And so people, I think, need support. And so regulatory systems, I think, should put more emphasis on that supporting role and take into account, when looking at disciplinary things like experience, things like the work environment, and stop making it about the individual. Because the individual alone is not the nature of the problem. We punish 3 individuals and the problem goes away. The problem is almost certainly going to have structural aspects to it, and the regulator should be looking at those structural aspects. To a certain extent that has happened. There's now a firm regulation, as in regulation of firms, and that's an attempt to respond to that demand, but for various reasons I don't think it's fully successful. But I think that's kind of what the article's trying to help readers and regulators and people thinking about this to see. When we're dealing with something that's hard to do that we want to happen, we have to facilitate, we have to give support, we have to put resources in place so that people can do that thing. It isn't that difficult to get people to behave in a weak fashion, to kind of be browbeaten, to not blow the whistle. That's not a huge problem. The problem is, and we're lucky in our society, that we still have people that are willing to take risks for the public good, for the profession, for the public. There still are such people, and we are lucky for that, because I don't think we support them as much as we should.
No, definitely not. I mean, just to think of an example off the top of my head, what are your opinions on Julian Assange?
I think I'm really glad I'm not in a personal relationship with him. I think he's a hellishly awkward and difficult person. But I think amongst what he did were things that should have been done. I wouldn't kind of endorse everything he did and the way in which he did everything, but the way in which he was hounded, I don't think was useful. I don't think the lesson that future whistleblowers might have been learning was the lesson we want them to learn.
Yeah, no, I agree with that. Do you have any examples of whistleblowers that you think have been unjustly treated in the public eye off the top of your head?
Oh, off the top of my head, probably not. Certainly not in terms of names. Certainly within the health service, it's notorious that doctors that blow the whistle on bad clinical practice amongst their colleagues often end up working in Australia and other jurisdictions, partly because of the relatively unified structure of employment we have here, because of the dominance of the National Health Service, partly because of the attitude of managers within the health service, and partly, I suspect, because of the attitude of other doctors. There have been several notorious cases of, in effect, victimisation of whistleblowers in the health service.
It links in very nicely, thankfully, to something that I had made a note about. Mm-hmm. And this is probably my favourite quote from the article. Vulnerability theory does not try to restrict the regulators, but hold them to account. It recognises that they are not omnipotent or omniscient, but demands that they both recognise their own vulnerability and act to respond to it, and that of the actors for whom they have responsibility. And it's one of my favourite quotes, not just because it's true in the legal context, but obviously in a wider one as well, as we've kind of touched upon before. There seems to be an attitude that, especially in a work context, accepting vulnerability seems to be some sort of acceptance that you're not doing the job good enough, or that something's gone terribly wrong and you deserve to be fired and there's going to be a massive scandal or something. Would you agree with that point of view?
Yeah, I think there's a problem with there's a self-image problem for many legal professionals, where the legal professional is the living embodiment of this autonomous individual that is able to kind of drive. They're able to work ridiculous hours. They're able to sort of face off people and withstand social threat in terms of doing the task. They're able to be harsh and cut where that's the not physically cut, but to either socially or economically, or in terms of litigation, procedurally cut and take advantage of people without being soft. There's this idea of softness. And so this I think it's basically a hyper machismo kind of self-image, which women can indeed adopt. It's not that, and I think that is problematic for the profession. I think it's problematic for the people entering the profession, and I think it's something where Martha Feynman is telling us to do something which would actually be to our own benefit. That's one of the things about vulnerability theory, because if your self-image is like that, it's actually, you're going to let yourself down, because that self-image is not of a human being. And your vulnerabilities, which will still exist, because there's no way that our quirks and weaknesses would go away, you're going to be kind of suppressing and hiding, and they'll come out in unpredictable ways. It's kind of, we're going to end up reinventing Freudianism if we're not careful, because you can't be that thing which isn't human. Because it's inhuman, and all you can be is human. So instead of building alliances, instead of building communities of practice of mutual respect, instead of supporting people, if you're after personal advantage all the time, you are going to both create a horrible environment for other people, but actually you're going to create a horrible environment for yourself, because it's not a way to be. Such hyper masculinities, you find it in for example, the Nazi propaganda about the nature of the soldier. You find a similar, and you often find it conjoined with an imagery of mechanics, so that I am a machine, and sometimes you get that in self-image of lawyers. I'm the machine that kind of destroys the opposition. I think that is deeply bad for the profession and deeply bad for the individuals that adopt that, and that is important. Even bad people are important, partly because they can do a lot of damage, but partly because they're people. And the vulnerability theory, I hope, helps us to resist that temptation. And it's not something we do self-consciously. It's not something we decide to do. It's something that we kind of pick up almost by osmosis from social activity and representations. And I think the vulnerability theory, one of its powerful insights, is that we are all vulnerable, including the powerful, including those that have the power to cause damage, who are normally not seen as vulnerable. That's the thing. The idea is that they are powerful, they are autonomous, they are succeeding, and then there are other vulnerable people. And that is a deeply dystopic view of the world.
Yeah, once again, I completely agree. And actually, I think on the point of these lawyers who have this shell that they've built up over their career, and they're very used to not showing any emotion or not showing any vulnerability, I think it's important that we actually start to recognise those qualities in people as vulnerabilities, because they are usually defence mechanisms to some sort of perceived threat or uncomfortable feeling that person has, or for them, or for more senior lawyers, I guess it's just something that they've built up over time as a surefire defence mechanism.
Get the first punch in, as my dad told me. That was the life advice I got. And being a little bloke, it was really bad advice.
Yeah, I can definitely relate to that. I didn't have my growth spurt until I was about 16, so I was used to being about 6 inches smaller than everybody else. So what do you think informs or kind of maintains this culture?
Well, I think partly the larger culture in which it takes place. So the legal profession, it is. We talked earlier about perceived threat. It is under threat. So there is that, and the larger culture endorses this idea of the autonomous individual who kind of strides through life, determining things using their power of choice and will. And I think that kind of, because we are all part of our culture. So there's that. There's also, I suspect, there's something to do with, because legal practice hurts. So in the tiny amount of time I practiced, and it was a tiny amount of time, I was hurt by what was happening to my clients. Some of my clients were in distressing situations, and I couldn't actually solve those situations. I couldn't remove the pain. And I did what I could for them within the professional context. And so there's an awful lot of hurt in the world. And it's like doctors have to not be squeamish. Lawyers have to not be squeamish. And I think part of that persona, that self-image, is in effect an overreaction to what's probably was originally a very healthy empathy. But you can't go being empathic when you need to do the task. You have to be focused on the task. You have to therefore be able to step back from your feelings to that extent in order to do what your client needs you to do. Yeah, and that stepping back from your own emotional reactions in order to serve that client and do the right thing, that can, over time, if it becomes a callousing rather than a stepping back that you kind of refresh, that can become part of that process. So I think part of it is the nature of the job. It's not always an easy job. I found it a difficult job to do. I stopped doing it and went into academia.
It is definitely a very continuing trend, though, the high turnover of people who qualify as solicitor and then decide actually they have no interest whatsoever in doing that for the rest of their life. And I think for the reasons that you just described, that is probably exactly why. I'm not a solicitor to put that out there. I think it's very obvious though. But I am taking a case with NLS at the moment where, I led the client interview. I'm just did the submissions, and I'm going to go and represent him at the social security tribunal. And I empathise with your point of view, which is that you do very much have to not think about them as a person who you've met and who you can relate to, You just have to think about it. What are the merits of this case? What can I actually do for him? And definitely, to do the best job, it requires not being emotional about it.
Yeah, and I think that's difficult, and it's difficult. I think it's difficult to temper that, and I do think part of what makes it more difficult, and part of what leads to the loss of retention, the difficulties in retention, is workplace cultures where that machismo driving culture and that kind of over objectifying, over kind of removal, it just makes it unpleasant to work there. It's kind of, because it is a difficult job. You're trying to do it well, and the structure in which you're doing it is in effect sabotaging you. And the feeling of regulatory threat doesn't help with overcoming those difficulties. So I do think workplace cultures have become more problematic than they used to be. Like law firms, in my limited experience, were always places where power was concentrated with capital. So the money you had invested, it was your firm. You could do what you wanted. It was your firm. And I respected that as an employee. It wasn't like a public sector firm or a public sector organisation because there was someone that owned it, and the person that owned it was telling you what to do. And that aspect of it's always been there. And that aspect of it, though, has become. I think law firms have become, not all of them by any means. I don't want to suggest it is, but I think too many of them have become commercial enterprises that do law, rather than legal enterprises, professional enterprises that make money. I think that is problematic for the profession.
Would you be willing to name drop any specific firms?
No, I consider libel law to be a powerful disincentive.
Understandable. Yeah, I think that is actually everything that I wanted to cover. So thank you very much for coming on, because this has been a very, very interesting conversation. And I'm really glad that you agreed to come on board as a guest for my first episode, because, you know, you give a very kind of empathetic and down-to-earth energy.
Well, thank you very much for asking me. Thank you very much for those kind words. Thank you. I always think if a student that I taught that no longer has any reason to be nice to me still wants to talk to me, I must be doing something right. So thank you very much for still being willing to talk to me. And I think that's it. We're done.